Good afternoon, everyone. My name is Olivier Vrins. I'm a partner in IP department of Altius, and my colleague Bart, Bollen, and myself are very excited to present you the new regulation of the European Union on geographical indications for craft and industrial products. This is not our baby, but still we believe it's very important legal instrument to protect traditional know-how and cultural heritage in the EU. So we thought it would be worthwhile to dedicate a webinar to this new regulation. Craft and industrial products, geographical indications, what are we talking about? Well, some of you may be familiar already with some of these products, at least some of them. Murano glass, Bohemia glass, Barcelos ceramics, bluestone from Tournai, lace from Binge, Limoges porcelain, or the Albacete cutlery. They are all protected actually as geographical indications in the member states, or at least some member states, because not all the member states of the European Union protect these kind of products as geographical indications. And this is precisely because only a few of these member states, well, actually over half of them, 16 member states already provide for sui generis protection of geographical indications for craft and industrial products, but not all of them. And this is the reason why the Commission proposed a new regulation that would actually extend the protection of those geographical indications to all the EU. This presentation will be divided into three parts. In the first part, we will just briefly summarize the legal framework as it exists nowadays in the context of geographical indications. The second part of the presentation will be dedicated to the new regulation on craft and industrial design, geographical indications. And the third part, of course, will be a brief conclusion, how to prepare to register applications under the new regulation. So first, some general background information regarding this new regulation. What is the legal framework dealing with geographical indications for craft and industrial products? Well, as you know, there are a couple of international agreements dealing with geographical indications. The Paris Convention on the Protection of Industrial Property only contains a few provisions, in fact, about indications of source, so not really geographical indications as such, but still some interesting provisions. But the very first international agreement which contains provisions on geographical indications worldwide was actually the Lisbon Agreement, which was concluded in 1958, and which contains also provisions on a uniform application to register geographical indications throughout the world. It was followed in 1994 by the TRIPS Agreement, which does not provide for uniform application and registration procedure, but does contain minimum standards regarding the protection of geographical indications. Then in 2015, the Geneva Act of the Lisbon Agreement was adopted, and the Geneva Act is very important. We will focus on this act in this presentation very much. Why? Because it gives the possibility to associations of member states, such as the EU, to accede to the system actually provided by the Lisbon Agreement. So the Geneva Act gives the possibility to associations of member states like the EU to actually offer protection for geographical indications as an entity. Next to these different international agreements, it is also possible to protect geographical indications by means of bilateral agreements. Many member states in the past have concluded bilateral agreements to protect geographical indications. There are also, as you may know, bilateral agreements between the EU and third countries, whereby the two parties undertake to protect each other's geographical indications. So this is for the international legal framework. In the European Union, there are different regulations which already exist since 1992 to protect some geographical indications, namely geographical indications in the food sector and for agricultural products. So there is a regulation on wine, a regulation on spirit drinks, and a regulation on foodstuffs, aromatized wines, and other agricultural products. So there was no regulation yet for non-food products. And this is the novelty of this new regulation, which we are going to discuss in this presentation. Non-food products could still be protected at national level until today. This is still the case, as I've discussed in the very first slide. The member states may provide protection for craft and industrial products as a geographical indication or by means of another protection scheme. And as I said, 16 member states nowadays have already provided for some legal protection scheme for geographical indications for non-food products. Others protect these kind of products under consumer protection law or trademark law. So this means there is a huge disparity between the member states regarding the scope of protection of the different protection schemes. Some protect it as a geographical indication, others as a trademark, others under consumer protection law. There are also huge differences in terms of the application procedure to register geographical indications for non-food products. And this is precisely the reason why the European Union wanted to harmonize this sector and to actually provide a common playing level field to all players throughout the EU by means of this new regulation 2023/2411. The new protection scheme proposes to protect craft and industrial products by means of a geographical indications. Those of you who are familiar with geographical indications may know that there is actually a major difference between geographical indications on the one hand and designations of origin or appellations of origin on the other hand. What is the difference? Well, the difference is that the geographical indication protects the quality, the reputation, or other characteristics of a product, which are essentially linked to the geographical area. So there must be a link between these characteristics or the reputation of the product and the geographical area. But this link may be a bit more loose than for designations of origin. It must be essentially linked, but not exclusively linked to the geographical area. And as a consequence, not all the production steps of the product need to take place in the geographical area. It is sufficient that only one or more production steps take place in the geographical area. It is not necessary that all steps take place in this area. This is the difference with designations of origin or appellations of origin, which actually aim to protect the quality or other characteristics of the product, which are essentially or exclusively attributable to the geographical area. And in that case, all steps of production must take place in the geographical area. So this is a major difference, and you see already that the geographical indications are actually more flexible for craft and industrial products because they do not require that all steps of production take place within the geographical area in question. Why are geographical indications so important? Well, first of all, because there is a need to protect know-how in the member states, the traditional know-how, traditional production methods of specific products, cultural heritage, and the know-how of local communities are very important to protect, but also because consumers pay increasing attention to the origin and characteristics of products. And because they pay increasing attention to the characteristics and origin of products, they are also willing to pay more for a product which provides some guarantees in terms of geographical origin or other characteristics. A study made by European Commission shows that they are actually prepared to pay at least sometimes twice the price of a similar product which is not protected by geographical indication. So you see, a geographical indication gives the producers the possibility to sell their products with a premium. Geographical indications should not be confused with other protection schemes. You know that there are also trademarks which can be protected and registered in the EU. There are different types of trademarks: individual trademarks, collective marks, and certification marks. But normally, the function of a trademark is completely different from the function of a geographical indication. And certainly, in case of individual trademarks and collective trademarks, the function of these rights is not to indicate the geographical origin of the product or other characteristics of the product, but to indicate the commercial origin of a product. It serves to distinguish the products of one undertaking from the products of other undertakings. If you take, for example, the trademark Signoretti, which is one of the individual trademarks owned by a producer of Murano glass, well, this trademark doesn't aim to indicate the geographical origin of the product or other characteristics of the product, but it aims to indicate that this type of Murano glass is actually produced by one specific undertaking called Signoretti. Likewise, for collective marks, you can see here on the screen the Dentelle de Calais. Dentelle de Calais is actually a geographical indication in France, but here they have applied and registered a collective mark, which shows that the product is actually produced by a member of an association of producers, and all the members of this association are allowed to use this collective mark. And so you can see here a good example where a trademark and a geographical indication can be used together, for example, on the packaging of products to show not only that a product comes from a specific undertaking or from a group of undertakings, but also that it shares some characteristics regarding quality, reputation, etc., linked to the geographical origin of the product. Then you also have certification marks and guarantee marks. These are more similar to geographical indications because they do not serve to indicate the commercial origin of a product, but they serve to indicate some characteristics of the product, like the fair trade trademark, for example, is certification mark. It shows that the product complies with some requirements in origin and participation in the profits of the product. It is a certification mark. But you should know that certification marks cannot serve to indicate the geographical origin of a product. It is prohibited to register a trademark which concerns a geographical name or aims to certify the origin in terms of geographical area of a product. So you could not get a certification mark in the EU for a geographical name or any other sign which indicates the geographical area of the product. And this is where geographical indications are absolutely crucial, because they do fulfill this function, and so they can be used together with trademarks and other protection schemes. Now we will shortly deal with the new regulation. What are the main characteristics of this new regulation on craft and industrial GIs? Well, the main characteristic is, of course, as I already said, that such products will be protected as geographical indications, not as designations of origin or appellations of origin. So it is sufficient that at least one step of production takes place in the geographical area. These geographical indications are intellectual property rights. What does that mean and why is it important? Well, it is important because as intellectual property rights, a number of instruments, procedures and remedies that are being provided by the EU legislator can be used to enforce these rights. I will discuss that later on in the presentation, but it is important to mention in this respect that all the tools that are linked to intellectual property rights can be used to enforce geographical indications. Next, these are collective rights. A geographical indication is not an exclusive right which is linked to one specific producer or company. It is a collective right, and regardless of who applied for the registration and protection of the geographical indication, a geographical indication can be used by all producers operating in the geographical area which comply with the product specification of the product. So everyone can use it without a license, provided that it complies with the product specification of the product. The protection applies throughout the whole EU, so it covers the entire 27 member states. This is a novelty of the new regulation, as I said, because previously, and actually still nowadays, these geographical indications can only be protected member state by member state. And it is also exhaustive, or it will become exhaustive because it will replace the protection which already exists now under the national law of the member states. This means that as from the 2nd of December 2026, the protection for national geographical indications will disappear and will be replaced fully by the new regulation. We will explain the consequences of this, the exhaustivity of this system in a moment in the presentation. And finally, the regulation aims to provide for a simple and cost-efficient registration procedure. Well, we will leave it up to you to judge whether the procedure which is being provided in the new regulation is indeed simple and cost-efficient. We believe it's not so easy, but still it has the advantage of being a uniform application procedure covering the whole EU. The legislative process regarding this new regulation, well, discussions have been ongoing at least since 2018, if not even before, regarding the possibility to extend the existing legal framework on geographical indications to cover also non-food products. So this is not a new topic, but it's only in April 2022 that the Commission eventually came up with a proposal for this new regulation. And this new regulation was adopted under Spanish presidency in October 2023. It was published in the official journal of the EU at the end of October 2023. And it entered into force on the 16th of November, so 2 weeks ago, in the EU. But entry into force doesn't obviously mean that it is already possible to file applications for these geographical indications. No, only part of these provisions have become applicable as from the 16th of November 2023. These are the provisions which mandate the member states and the UIPO to already prepare for to place all the mechanisms that are necessary to be able to file applications for GIs, but it will only be possible to actually file specific applications as from the 1st of December 2025. So the whole regulation will actually become applicable as from that date, 1st of December 2025, where it will become possible to file the very first applications for registration. And as I already said a few minutes ago, as from the 2nd of December 2026, the national protection provided for geographical indications for craft and industrial products will end, and the regulation will fully replace and supersede the national protection which currently exists. What are the objectives of the regulation? Well, they are manifold. The first objective is obviously, as I said, to harmonize the existing legal framework. There have been disparities in terms of scope of protection, registration procedures throughout the member states. As I already said, the new regulation wants to provide for a uniform and harmonized legal framework, which also will harmonize the scope of protection of these rights. The second objective of the regulation is to allow the EU to meet its obligations under the Geneva Act of the Lisbon Agreement. As I said, the EU acceded to the Geneva Act in 2019, which means that as from that very date, well, at least the entry into force towards the EU in 2020 of the Geneva Act, the EU must be able to provide and offer protection for craft and industrial GIs, also from non-EU member states, as a result of the Geneva Act. And in order to be able to meet these obligations, well, the regulation has been adopted. Another objective of the regulation is to provide new opportunities for the producers to enhance the competitiveness of these producers. As I said, producers who produce products with a geographical indication are mostly able to charge a premium for the sale of such products. And so it is believed that the new regulation will actually strengthen the competitivity of EU producers. The fourth objective of the regulation is to better inform consumers about the qualities and characteristics of products which benefit from a geographical indication by allowing producers to use a geographical indication on the packaging, the labels of the products, etc. It will better inform consumers as to the geographical origin, reputation, and other characteristics of the product. And then finally, there are a number of spillover effects which are believed to be achieved by the new regulation. Promotion of tourism. If you go and visit Murano, it's mostly not because of the island by itself, but because of the Murano glass, while it is hoped that in less developed areas where there is a geographical indication, where there is a traditional know-how and cultural heritage, that this will actually stimulate tourism. It is also believed that the new regulation will create jobs in these areas and will also, as a consequence, help to fight against depopulation in these geographical areas. These are the objectives of the regulation. And now I give the floor to Bart, who will actually explain the conditions of protection of these provided by the regulation.
Thank you, Olivier. Good afternoon to everyone. Also from my side, my name is Bart. I'm an associate here at in the IP department at Altius, and I have the pleasure of guiding you through a large chunk of the substantive provisions of the regulation. And I propose we immediately dive in because we have quite some ground to cover. So as was already mentioned by Olivier, GI protection has for many years existed in the agricultural sector. But now, in light of the EU's accession to the Geneva Act, it was appropriate and even necessary to extend GI protection in the EU to craft and industrial products. Two terms that have been defined in the regulation as follows. A craft product is produced either totally by hand or with the aid of manual or digital tools or by mechanical means, whenever the manual contribution is an important component in the finished product. On the other hand, an industrial product is defined as produced in a standardized way, including serial production and through the use of machines. Now, in any case, it is clear that products that are already enjoying GI protection through an existing scheme are excluded from the scope of protection of the present regulation. This also applies to the traditional specialties guaranteed. Now, a craft or industrial product must satisfy three requirements cumulatively to establish a link to a certain geographical area before GI protection can be granted. And these three cumulative requirements are as follows. The product must originate in a specific place, region, or country. The quality, reputation, or other characteristic of the product is essentially attributable to this geographical origin. And thirdly, at least one of the production steps must take place in this geographical area. A production step being defined as any stage of production up to the point where the product is in a form to be placed on the market, and this can include manufacturing, processing, obtaining, extracting, cutting, or preparation. Now, regardless of the fulfillment of these requirements, certain products are a priori excluded from GI protection. These are, for example, the products that are contrary to public order. As to partly or wholly homonymous names, meaning words that are spelled or pronounced in the same way but refer to something else, the situation is as follows. If one submits an application for GI protection after a wholly or partly homonymous name has been applied for or is already protected, that application shall be rejected, but only if the protection of both names would mislead the consumer as to the true identity or geographical origin of the products in question. For generic names, this is when consumers no longer perceive the name as an indication of a given product's geographical origin. It is much clearer. They are also a priori excluded from GI protection. For example, in France, discussion has arisen as to whether Layol has become a generic name or not. Also, misuses arguably cannot lead to GI protection. In that sense, reference can be made to the recent ruling of the General Court in the Île-de-Beauté case. In that case, the General Court actually confirmed the Commission's assessment that 3 PGI applications relating to the term Île-de-Beauté could not be accepted in light of 3 earlier registered PDOs relating to the term Corse, as they refer to the same geographical area, namely the island of Corsica. Now, as to the identity of the applicant, the default situation is that the relevant producer group will apply for GI protection, and this has been defined as any association, irrespective of its legal form, of operators mainly working with the product and engaged in one or more production steps. Now, the regulation nevertheless foresees that other persons or entities can qualify as applicant. For example, a single producer can be an applicant if no other producer is interested in applying. The geographical area concerned is not limited to mere private property boundaries, and the characteristics of that area differ appreciably from those of neighboring areas, or characteristics of the product differ from those of products produced in neighboring areas. On the other hand, a regional or local authority or private authority designated by a member state can also be an applicant within the meaning of the regulation. If an application is submitted in this way, then it must state the reasons why it was submitted by this particular entity. Now, in any case, authorities designated to handle GI applications at the national level and those in charge of controls, they cannot wear the quote-unquote double hat of applicant. For non-EU GIs, it is either the producer group or the third country authority that acts as applicant. And finally, the regulation also foresees in the possibility of submitting a so-called joint or cross-border application where the product originates in a cross-border geographical area. This area could be made up of, for example, several member states, but also member state and third country, or even several third countries. In other words, there will still be multiple applicants, but only one joint application. One could say that the end goal of any applicant in this system is the registration, as this will be the event that actually confers GI protection. But there are actually different routes to get to that final destination of registration. For GIs originating in member states, they will need to follow the compulsory route of the regulation that we are now talking about. If applicants are successful under the regulation, the scope of protection will, however, be limited to the territory of the EU. Now, to broaden that protection, one can pursue the routes of an international registration under the Geneva Act, or the protection through an EU negotiated and concluded bilateral agreement, if it exists. On the other hand, GIs originating from third countries, so outside of the EU, they can gain protection in the EU via alternative ways. So they can opt to either take the route of the regulation, the international registration under the Geneva Act, or the bilateral agreement to which the EU is a party, again, if it exists. As previously mentioned, non-EU GIs can benefit from a direct registration under the regulation, where there will be only one stage, namely at EU level. And it will be for the EU IPO or the Commission, should it decide to take over from the EU IPO, and with the assistance of the advisory board, which is to be established, to, and you can see it on the screen, examine and publish the application, organize a worldwide opposition procedure, take a final decision on registration, and finally the publication in the EU IPO register. For the international agreements route, the principle of reciprocity applies in principle, meaning that the signing parties will accord a similar level of protection to their respective GIs. Please note that for the bilateral agreements as they exist today, it is the European Commission who has the competence to examine these applications, whereas the EU has now designated the EU IPO as the competent authority for the purposes of the Geneva Act. For names that are already protected as GIs in the member states, a specific regime has been set up. By the 2nd of December 2025. All member states must notify to the EU IPO and the Commission the existing names they wish to see protected under the regulation. They will then find themselves in a sort of fast-track registration process whereby the EU IPO or the Commission, as the case may be, will check whether the requirements of the regulation are fulfilled. And no opposition procedure is foreseen in this particular scenario. For names not yet protected in a member state, the situation is quite different. As you can see on the screen, there are two separate procedures. On the one hand, there is a standard procedure, which, as its name reveals, is a standard route to follow for GI registration. And there is a direct registration procedure, which applies only exceptionally. As far as the standard procedure is concerned, it is divided into two phases. First up is the national phase at member state level. This includes the examination and publication of the application, the possibility to file an opposition within 2 months of that publication, the actual decision on the application with a right of appeal directly guaranteed by the regulation, and the final rejection of the application or the transmission of the dossier to the EU IPO following a positive decision. We then arrive at the union phase of the standard procedure, where the EU IPO and possibly the Commission, if it decides to take over, play a central role. The union phase kicks off with a limited scrutiny of the application that they received from the member state in question. Now, this limited scrutiny includes a check on manifest errors, the completeness of the information provided, and the compliance of the single document. If the application passes this limited scrutiny test, it gets published, after which a worldwide opposition procedure can be opened. Opposition can be filed within 3 months after publication of the dossier, and after opposition, a final decision on registration is taken by the EU IPO or the Commission. The union phase then ends with the publication of the end decision. Apart from the standard procedure, there is also the direct registration procedure, which comprises only one stage or phase, so to say, which is at EU level. This exceptional route can be used for non-EU GIs and for EU GIs that originate in a member state that obtained a derogation. More about that in a minute. In any case, EU IPO or the Commission, as the case may be, will be the only instance looking at the application, based this time on a detailed examination, after which publication takes place. The other steps remain roughly the same. Zooming in on the national phase, one of the most important obligations for member states under the regulation is that they should designate a competent authority to conduct this national phase. And the deadline here is the 1st of December 2025. As mentioned before, the member states have the option to opt out from the standard procedure, meaning that they will not, quote unquote, host a national phase. This is, however, subject to the Commission's approval, whereby the member state in question will have to prove that first, it currently does not have a national system in place for CIGIs, and second, it must adduce evidence of a minimal local interest to protect CIGIs. Member states will have to file their requests for derogation by the 30th of November 2024. It is important to stress, however, that this derogation is not a wild card for exemption from other parts of the regulation, in particular the obligation to designate a single point of contact and obligations relating to controls and enforcement of the regulation. Within the union phase of the standard procedure and within the direct registration procedure, where there is only a union phase, the competent authority is in principle the EU IPO. In practice, the work under the regulation will be carried out by the newly to be established Geographical Indications Division. Exceptionally, however, the European Commission may substitute itself for the EU IPO at any time before the end of the procedure. This can happen on its own initiative, but also on the member states or even the EU IPO's own request. Now, such an intervention is only possible where the GI applied for might be contrary to public policy, or the registration or rejection might jeopardize the EU's trade or external relations. In line with the spirit of linguistic equality that we know in the EU, communications with the EU IPO can take place in all official languages of the EU. It's 24, if my memory serves me right. And also the publication of single documents will happen in all official EU languages, which will be very beneficial for small, medium, and for micro, small, and medium-sized enterprises. The regulation also contains some provision that guarantee some forms of assistance with applicants, because a lot of them, or most of them, will probably be these micro, small, and medium-sized enterprises. So it will be this assistance can relate to the preparation of, for example, the single document, but it can also be more general, as, for example, giving advice, the sharing of documents, contacts, and other relevant information, so that these entities will be helped through the application process. We now move on to the subject of opposition, the goal of which is to prevent a GI registration, and which can occur both at the national phase and the union phase. During the national phase, an opposition can be filed by any natural or legal person having a legitimate interest, who is established or resident in the member state, who is in charge of the national registration phase, or in the member state in which the product originates. Now, in the union phase of the standard procedure or the direct registration procedure, the identity of the possible opponent is a little bit different. This can first of all be the competent authority of a member state or a third country. Secondly, opposition can be filed by any natural or legal person having a legitimate interest and established or resident in a third country or in a member state other than the member state in charge of the national phase or the member state in which the product originates. So a previous national opponent is thus expressly excluded from filing a second opposition at union level. An opposition can be filed on one or multiple grounds, but only those laid down in the regulation itself, and which you can see on the slide. So non-compliance with the requirements for protection, genericity of the candidate name, in case of homonyms, a conflict with an earlier trademark whereby the latter is well known or has reputation, and this at the risk of misleading consumers, and where it would jeopardize the existence of an identical or similar name used in trade or of a trademark, or the existence of products that have been legally on the market for at least 5 years preceding the date of the publication. From a procedural perspective, the first thing that the competent authority should do is to decide on the admissibility of the opposition. This means checking whether the opposition contains all the information specified in the standard form for a reasoned statement of opposition, which you can find in Annex 3 of the regulation. Once admissibility has been established, the case moves forward, and the opponent and applicant will engage in consultations with each other for maximum 3 months to try and reach a friendly settlement. The competent authority can then extend that period for another 3 months, but only at the parties' joint request. If a settlement is indeed reached, and this contains major amendments, then there will be a new examination of the application and also a republication. If in the end no settlement can be reached, the competent authority will decide to either refuse or allow the registration. Where it allows the registration, it may subject this to a possible transitional period of maximum 5 years or 15 years in some cases. Apart from the classical opposition, the regulation also foresees in the possibilities to submit a notice of comments with the EU IPO within 3 months from publication in the Union Register. And that refers to the single document, publication of the single document, and the reference to the product specification. This can be done not only by a competent authority of a member state or a third country, but also by any natural or legal person having a legitimate interest and established or resident in a third country or in another member state. The fact that the regulation refers or expressly refers to another member state implies, in our view, that here too the national opponent is excluded from this possibility. The notice of comments cannot invoke the opposition grounds, but, for example, it can point out possible infringements of other EU legislation or inaccuracies in the application. The notice is, moreover, shared with the applicants. Moving on to cancellation, which is no longer about trying to prevent a registration of a GI, but about removing an already registered one. Cancellation may be requested by EU third countries, interested parties, and even the EU IPO or the Commission, where the compliance of the product with the product specification can no longer be ensured, or where no product has been placed on the market under the GI for at least 5 consecutive years. On the other hand, the registration of a geographical indication shall be cancelled in case of a generic term, homonym, or where, in light of a trademark with a reputation or well-known mark, the proposed GI would be liable to mislead consumers. Now, contrary to opposition, there is no deadline within which a cancellation should be filed. And lastly, the regulation foresees in both a national and union phase for the cancellation procedure. After a decision has been rendered by the EU IPO on the registration, whether it's positive or negative, an appeal can be lodged before the EU IPO boards of appeal. And similar to trademark cases, a further recourse to the EU General Court and even the Court of Justice is perfectly possible. When an application for GI protection is submitted, it should be accompanied by several pieces of information. Arguably, the most important piece of information is the so-called product specification. And in short, the product specification is elaborated by the producer group of a product, and it's a shared definition of the production and processing practices in the relevant geographical area concerning the product in question. There is no predetermined format for this in the EU, but it should contain at least the elements that you see listed on the slide. Another important document is the single document, for which does exist a standard form, and which you will find in Annex 2 of the regulation, and it serves as a sort of summary of the product specification containing the most essential elements thereof. There is also the so-called accompanying documentation, which refers to more practical information, such as the name and contact details of the applicant and the competent authority at national level. Specifically for non-EU GIs, the proof of protection as a GI in the country of origin must be provided, as well as a power of attorney if the applicant wishes to be represented by an agent for the purposes of the procedure in the EU. Although it will likely take a while before we see this in practice, allow me to very briefly discuss the different kind of amendments of the product specification that might occur. Per the regulation, there are 2 categories of amendments to a product specification. First of all, there are the union amendments. Such amendments always require a revision of the single document, and which include a change in the name of the GI or in the use of name, or risks undermining the link to the geographical area, or entails further restrictions on the marketing of the product. In any case, for union amendments, the legislator has foreseen that the national and union phases shall apply here as well. Secondly, all other amendments to the product specification can be classified as so-called standard amendments. These are only dealt with at national level, not at EU level, either by a member state or a third country, depending on where the GI originates from. If, however, the GI originates from a member state that obtained a derogation from the standard procedure, remember, then the standard amendment will, after all, be dealt with by the EU IPO. This was it for me, so I will now gladly cede back the mic to Olivier for the rest of the presentation.
Thank you very much, Bart. Now, the next slide concerns the scope of protection of geographical indications. Once you have successfully registered your geographical indication, what are the rights that are actually associated with these geographical indications? Well, a geographical indication will give the producers or the groups of producers the right to prohibit the use of these names or similar names in different cases. First of all, it will be prohibited to use the name or a similar name for comparable products which do not comply with the product specifications. Take, for example, Murano glass, as we took this example at the very beginning of this presentation, when someone, even within the geographical area, produces Murano glass but does not comply with the product specifications, or a fortiori, if it is a producer outside the geographical area which uses the name Murano glass to produce glass products, well, of course, this type of uses can be prohibited. The use can also be prohibited for non-comparable products if it amounts to a misappropriation, so if it takes unfair advantage of the reputation of the geographical indication, or if it weakens or dilutes the geographical indication. So in that case, the scope of protection also extends to non-comparable products, which obviously goes very far. Protection is also afforded against evocations. Take, for example, the case where someone would use images of the Carnival of Binge to promote lace, which is not lace from Binge. Well, this is an evocation of Binge, although the name Binge or lace of Binge is not explicitly used on the packaging or the labeling of the product. This is an evocation of the geographical indication that can be prohibited, and any other misleading indication on the packaging or labeling of the product would also be prohibited. The scope of protection extends both offline and online, and this is very important to notice. So public marketplaces, but also online platforms selling products to EU consumers could be prohibited to use names which are identical or similar or evoke a protected geographical indication if the products do not comply with the product specifications. And this is also the case for domain names. The regulation provides that there must be some procedures in place to prevent the abusive registration of domain names, which include part or hold the geographical indication. So, for example, again, a domain name muranoglass.it that would actually sell products which are not Murano glass or other types of glass products would or should actually be refused, and the sale of these products would also be prohibited. Use in the name of a manufactured product, well, take for example the case where you would use as a component of your complex product Murano glass. You are allowed in that case to refer to the fact that this component is genuine Murano glass, which is protected by geographical indication, but you may only do that provided this is in accordance with fair trade practices and subject to the producer group's consent. So you need to obtain the consent of the producer group in order to be able to use the geographical indication in that case. Conflicts with trademarks. Conflicts between trademarks and geographical indications. Well, two scenarios must be distinguished in this case. The first case, the easiest one, is where you have registered a geographical indication and someone else later on comes on the market and registers or uses a trademark which actually would violate the scope of protection of the geographical indication. Well, in that case, the trademark should be refused registration. It cannot be accepted for registration, or it can be invalidated if it has been registered, and the use of that trademark will obviously be prohibited. The situation is a bit more complicated when there was already a trademark on the market with the name in question or a similar name, and you try to register subsequently a geographical indication. Well, in that case, you need to distinguish whether the trademark which was already on the market in the EU is a well-known trademark or trademark with a reputation. If this is the case, then normally the proprietor of the trademark will be able to to oppose the registration of the geographical name, the geographical indications, if this is liable to mislead the consumers as to the true identity of the product. So if the trademark proprietor can prove in that case that use and registration of the geographical indication would mislead the consumers, then it can actually request that the geographical indication be rejected. Another case concerns a case where there was already a trademark on the market in the EU, but that trademark is not actually well known and has no reputation. It is used at a very limited level. Well, in that case, and provided the trademark in question has been registered and used in good faith, in that case, both names can coexist. So the trademark proprietor will not be able to oppose the registration of the geographical indication, but likewise, the group of producers will not be able to rely on the geographical indication to prevent the use or registration of the trademark in question. A very important mechanism under geographical indications law concerns the control and monitoring of products on the market, because obviously if you do not control compliance of the product with the product specifications, then the geographical indication is completely weakened, diluted, and fails to fulfill its function, which is to guarantee to the consumers that a product has some specific characteristics or reputation linked to the geographical area. So control mechanism needs to be put in place. And in this respect, the regulation actually provides kind of default mechanism, which is the self-declaration certification, whereby the producers themselves, before the product is put on the market, would actually fulfill declaration, and there is actually a template attached to the regulation that can be filled in, whereby they declare that their product complies with the product specification. So this is before the product is placed on the market. Once the product has been placed on the market, every 3 years, they need to fill in a new declaration whereby they certify that their product still complies with the product specification. They need to return this form to the public authorities, and the public authorities will make a check to make sure that the information that is being provided is complete and accurate. Obviously, the public authorities later on, so once the product is on the market, can perform random checks to make sure that the products which are on the market comply with the product specifications. So this is the default rule, but the member states may choose another mechanism. They may actually decide that this self-declaration will not be sufficient, and they may decide to appoint an authority. It can be a public authority or even a third party, a certification body, which in that case must comply with some certification standards. And those authorities or certification bodies will then be in charge to control compliance with the product specifications before the product is placed on the market and after it is placed on the market. So it is much more burdensome for the member states, this alternative mechanism. It remains to be seen whether they will actually choose this mechanism. The self-declaration mechanism is not provided for agricultural GIs, so it is a much more flexible regime that has been provided here for craftsmen and for micro and small size undertakings. For GIs coming from third countries, if you have a geographical indication which is registered in a third country and you want to claim to register it also for the EU, then the control mechanism will need to take place by a public authority or by a certification body. Self-declaration certifications will not be provided in that case. So once you have got this control mechanism before the product is being placed on the market, then obviously the member states need to monitor the market very carefully to make sure that there are no infringing products that are being placed on the market. And they should appoint to that effect an authority which will be competent to carry out these controls. It can be, and it will be, the customs authorities at the borders of the EU. It can be law enforcement authorities, or for example, the police, or it can be market surveillance authorities. In Belgium, for example, it is the Ministry of Economic Affairs, but they have to appoint a competent authority to that for that purpose. And obviously, the controls and the monitoring also need to take place online. The producers, as far as they are concerned, should also perform compliance checks from time to time at random, and they should support and help the public authorities in their monitoring activities. They should also report non-compliant products to the public authorities so that they can actually sue the infringers. Well, as I said, geographical indications are intellectual property rights. That means that all the procedures and remedies provided for in the enforcement directive on the civil enforcement of IP rights, Directive 2004/48, they apply to geographical indications. And so you can actually rely on all these civil remedies and procedures to enforce geographical indications. The border measures regulation at the external borders of the EU, Regulation 608/2013, also applies to geographical indications, whatever they are. So all types of geographical indications protected under EU law are covered by the regulation. So the new regulation will actually also apply in this respect and give competence to the customs authorities to stop infringing products. Furthermore, the member states are mandated under the regulation to provide for penalties, administrative or criminal penalties, in case of non-compliance with the provisions of the regulations. And the regulation also provides that the member states should cooperate with each other in monitoring the market and enforcing geographical indications. Finally, as I said, the scope of protection of geographical indication extends to online sales as well. And as a result, the Digital Services Act will also apply, which will allow the producers and groups of producers to fight illegal content offered online, and if necessary, to actually request orders from the courts to have these type of illegal contents removed from the internet. Is there a fee to be paid for the registration procedure and for the protection of geographical indications? Well, for the standard procedure, so the procedure provided in 2 phases, the regulation provides that the member states may charge a fee for the national phase of the procedure. They are not obliged to do that, but they may do that. And actually, we would probably expect them to charge a fee. But the regulation provides that the amount of the fee must take due account of micro and small and medium-sized enterprises, so that the fee should not be excessive. When there is a national phase, the EU IPO in the union phase is not allowed to charge fees. When there is a direct registration procedure, so there is a member state which has obtained a derogation, or it is a GI from a non-EU country, in that case there is no national phase, and the EU IPO is then allowed to charge a fee to cover this registration process. And the fee will be determined in implementing acts that have not yet been adopted by the Commission. How will the whole system, how much will the whole system cost for the producers, the national authorities, and the EU? Well, there is no clear figure in this respect, of course, but if you look at the EU impact assessment that was published before the Commission proposal was actually adopted, you will see that the Commission has made some kind of estimate of the costs. For the registration procedure, it would allegedly cost approximately 15,000 euro for the producers groups concerned for 1 GI, only for the registration. The verification and controls, the procedure is likely to cost approximately 5,700 euro for 1 GI, and the enforcement and management 3,000 euro. The cost for national authorities to implement the system is actually lower, but overall, I think, especially for the registration procedure, the estimate provided by the Commission is probably very conservative. If you take into account, for example, the standard procedure with 2 phases, national phase, where you can have an opposition and then an appeal, and then it is the application is transferred to the EU IPO, where you can again have an opposition, an appeal up to the Court of Justice, then obviously in these specific cases, the registration would most probably be much more costly than that. Finally, two slides to wrap up. Should you actually claim protection for your geographical indication? Should you not do that? Well, geographical indication, as it has become clear, I hope, in this presentation, offers a lot of advantages. You should not expect that you will be able to protect a geographical name or a geographical indication by means of a trademark. A trademark will not offer you the same advantages, the same scope of protection, and you cannot obtain a certification mark for geographical names. A trademark does not fulfill the same function as a geographical indication, and you should be very attentive to the fact that if you do not use your trademark in accordance with the function of a trademark, you are likely to lose your trademark. It can be revoked because it is not used in accordance with the function of a trademark. So it is important to also consider registering a GI on top of your trademark. The geographical indication will give you some exclusivity, at least within the geographical area, and subject to product specifications. As we have seen, it would also provide some kind of commercial competitive advantage, as it will allow you in principle to charge a premium also for the sale of products protected by a GI. It will grant you protection covering the whole European Union, obviously, it can be enforced across the whole EU very easily by means sometimes of easy proceedings. Obviously, if you want to consider the registration of a geographical indication, you should accept a collective approach. You should accept to sit around the table with your colleagues from the geographical area, with other producers, and discuss about the specifications of the product. What should be protected? What should not be protected? What should be required? What should not be required in producing the products? Where should the different production steps take place? So it is obviously a collective approach, because a GI is a collective right. You should therefore also accept to share expertise and work on the product specifications with your fellow producers in the geographical area. You should, in this respect, also accept to some extent to share your know-how, but they will have know-how as well in the geographical area in selling the product. And you should also accept to carry out controls and enforce your rights in a collective way. Obviously, in that case, you can appoint some associations or organization that will be responsible for enforcing the rights linked to the GI. Agenda from now on, well, you know that the regulation has already entered into force, but will not immediately become applicable in all its provisions. So for the producers, there are actually two deadlines to keep in mind. The first one is for the existing name. So if you are a producer or producer group in a member state and you have already protected your name in the member state in question, then you should make sure with the member state in question, where you are established, that that member state will notify the EU IPO and the European Commission before the 2nd of December 2026 of these existing names, and that the member states want these names to continue to be protected under the regulation. If you do not do that, the protection will disappear and you will not have any protection anymore for these names. If the name is not yet protected, of course, you should consider filing a registration under the new regulation, which will be possible as from the 1st of December 2025. Regarding the member states, well, they have also different deadlines to comply. And the first one is the 30th of November 2024. If they wish to request a derogation for the national phase of the procedure, if they want to be exempted from the national phase, they need to file a request before the 1st of December 2024, where they substantiate the reason why they have no experience or there is no great interest in geographical indications in their member state. If they do not intend to request for derogation, then they must appoint the competent authority by the 1st of December 2024. So they have 1 year to designate the competent authority to process applications in the national phase. By the 1st of December 2025, they need to adopt and notify the implementation measures they have taken in accordance with the regulation and the penalties they will provide in their national law in case of non-compliance with the regulation. And by the 2nd of December 2026, they will have to notify the existing names to be protected under the regulation. Again, if they fail to do that, they will actually lose protection, or the producers will lose protection for these names as from that date. UIPO, as far as it is concerned, has already started its activities under the regulation. It has set up a very nice GI hub, a website which is very informative on geographical indications, and I invite you to have a look at it. But by the 1st of December 2025, they will also have to set up the new Geographical Indications division that will examine applications, oppositions, cancellation procedures, etc. And they will also have to put in place the advisory board composed of representatives of the member states who will actually assist UIPO in the processing of these registrations and at different stages of the procedure. They will also need to provide for online filing and management system for geographical indications, a register where all these protected names will have to be recorded, and finally the database, which will allow everyone to retrieve easily all the protected names. And finally, the European Commission needs to adopt a series of implementing acts, including to determine the fees which will have to be paid in the processing of the direct registration or the union phase of the procedure. So there are a very filled agenda for the different bodies, and we are very anxious to see how the regulation will be applied and implemented in practice. Thank you very much for your attention. We will have a look at the Q&A to see if there are any questions. I cannot see any, but you have our particulars, your contact details here. Don't hesitate to drop an email if you have any questions you want us to address. And meanwhile, we wish you a very nice week, and we will keep in touch. We have seen now that a compromise has been reached between the Parliament, the Council, and the Commission regarding the reform of the agricultural geographical indications. A compromise has been reached on the 21st November of this year, so it is very recent as well. We expect to come back to you with the second part of the webinar on this specific reform very soon. Thank you very much. Bye-bye.